Clause 2. If after a bill has been so passed for the second time by the Legislative Assembly and transmitted to the Legislative Council. Subclause A. The bill is rejected by the Council, or Subclause B. More than 1 month elapses from the date on which the bill is laid before the Council without the bill being passed by it, or Subclause C. The bill is passed by the Council with amendments to which the Legislative Assembly does not agree. The bill shall be deemed to have been passed by the houses of the legislature of the state in the form in which it was passed by the Legislative Assembly for the second time, with such amendments, if any, and any as have been made or suggested by the Legislative Council and agreed to by the Legislative Assembly. Clause 3. Nothing in this article shall apply to a money bill. Article 198. Special procedure in respect of money bills. Clause 1. A money bill shall not be introduced in a legislative council. Clause 2. After a money bill has been passed by the legislative assembly of a state having a legislative council, it shall be transmitted to the legislative council for its recommendation, and the legislative council shall, within a period of 14 days from the date of its receipt of the bill, return the bill to the Legislative Assembly with its recommendation, and the Legislative Assembly may thereupon either accept or reject all or any of the recommendation of the Legislative Council. Clause 3. If the Legislative Assembly accept any of the recommendation of the Legislative Council, the money bill shall be deemed to have been passed by both houses with the amendments recommendation by the Legislative Council and accepted by the Legislative Assembly. Clause 4. If the Legislative Assembly does not accept any of the recommendation of the Legislative Council, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the Legislative Assembly without any of the amendments recommended by the Legislative Council. Clause 5. If a money bill passed by the Legislative Assembly and transmitted to the Legislative Council for its recommendation is not returned to the Legislative Assembly within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the Legislative Assembly. Article 199. Definition of money bills. Clause 1. For the purpose of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely: Subclause A. The imposition, abolition, remission, alteration or regulation of any tax. Subclause B. The regulation of the borrowing of money or the giving of any guarantee by the state or the amendment of the law with respect to any financial obligation undertaken or to be undertaken by the state. Subclause C. The custody of the consolidated fund or the contingency fund of the state, the payment of money into or withdrawal of monies from any such fund. Subclause D. The appropriation of monies out of the consolidated fund of the state. Subclause E. The declaring of any expenditure to be expenditure charged on the consolidated fund of the state, or the increasing of the amount of any such expenditure. Subclause F. The receipt of money on account of the consolidated fund of the state or the public account of the state, or the custody or issue of such money, or subclause G. Any matter incidental to any of the matters specified in subclauses A to F. Clause 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for license or fees for services rendered, or by reasons that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Clause 3. If any question arises whether a bill introduced in the legislature of a state which has a legislative council is a money bill or not, the decision of the Speaker of the Legislative Assembly of such state thereon shall be final. Clause 4. There shall be endorsed on every money bill when it is transmitted to the Legislative Council under Article 198, and when it is presented to the Governor for assent under Article 200, the certificate of the Speaker of the Legislative Assembly signed by him that it is a money bill.